Today we're going to be talking about traveling abroad with your permanent residence and some issues that might come up that could affect your ability to re-enter the US. We're going to be talking about some subjects including abandonment of your permanent residency, inadmissibility if you're not allowed back in, what it's like to travel to other countries, what the requirements are, and a bunch of other topics. If you're new to this channel, I'm Puyan Darian, an immigration lawyer, and I put out a new video each week. So without further ado, here we go. The first thing I like to discuss with my clients after they become a permanent resident and get their green card is the travel requirements and how they can affect your timeline for naturalization, becoming a US citizen. When you apply for citizenship, you need to have your green card for at least 3 years if you're married to a US citizen and living with them the whole time, or 5 years if you're anybody else who has a green card. So most people will need to have their green card for 5 years if they're not doing it based on marriage to a US citizen before they could apply for citizenship, naturalization. Before you apply, whether it's 3 years or 5 years, there are 2 travel requirements to keep in mind. The first one is you must have spent at least 51% of those 3 or 5 years inside the United States. And the second rule is you cannot leave the US for more than 6 months in a single trip without affecting the continuous residence requirement of naturalization. Let's say you leave the country and you come back 7 months later. Aside from other problems that might arise from doing that, such as abandonment, which we'll discuss down the road, you won't be eligible for citizenship immediately. Those 3 or 5 years will restart from there because you need to show continuous residence for naturalization. So that's the first thing to keep in mind. The issue of abandonment is a really serious one. Immigration can always question whether you've intended to permanently reside in the US when you re-enter the US. And by immigration here, I mean Customs and Border Protection, CBP. So when you're re-entering, even if your trip was only for 5 months, CBP might say, hey, based on your travel history, it looks like you left for 5 months, you've been in the US for 1 month, and then you left for 5 months, you've been in the US for 1 month, and you did that a few times. We think that you're actually living abroad in a foreign country and you don't intend to permanently reside in the US. That could happen if you don't spend most of your time in the US. But also, if you leave for more than 6 months, you're more likely in a single trip, if you leave for more than 6 months, you're way more likely to get questions from CBP about what you were doing, whether you've maintained a permanent address in the US, and whether your intention during that time was to continue residing in the US. And they could even bring you to a back room, it's called secondary inspection, and pressure you into signing an abandonment of residency form. It's called I-407. If that happens, I would not sign the form. You'll likely receive a notice to appear in immigration court, and at that point you need to get an immigration lawyer. It's fixable if we can show that your intention was to continue living in the US as a permanent resident. This is much more likely to happen if you spend more than 12 consecutive months outside of the US during a single trip. There is a presumption of abandonment if you do that, and you're way more likely to have problems coming in. Now, with that said, I've seen people who've spent 7 years outside of the US and they come back and they just get stamped into the US without issue. Now, those people are more likely to have issues if they ever apply for naturalization, and they might even be removable, deportable from the US for the rest of their lives as permanent residents, so it just increases risks moving forward. One final note about leaving the US for long periods of time. Let's say you have a family member who's really sick and you need to go and spend time with them and you think it's gonna be longer than a year, or even just longer than 6 months, and you have no idea. They have cancer or some terminal illness, and you don't know if you're gonna spend 1 year or longer outside of the US with them. There's a way to leave the US for up to 2 years during a single trip without affecting your green card. It's called applying for a re-entry permit. It's done by filing Form I-131, and if you ever have difficulty with this or want a lawyer to do it for you, you could always schedule a consultation with me and my office can handle that. The next thing to keep in mind when you're traveling is that you use your green card to re-enter the US. But every other country you enter, you need your foreign passport to enter. So whatever country you're a citizen of, you would need that passport. It needs to be unexpired, and you need to pay attention to the visa requirements in that country. For example, if you're a citizen of Mexico and you have a Mexican passport and you have a US green card and you want to travel to some European country, you need to look to see whether that country requires visas for citizens of Mexico, or if there's some sort of visa exemption for permanent residents of the United States, which is the case in some countries. But you're not traveling as a citizen of the US. They might say US citizens can just enter, they don't need a visa in advance, but citizens of Mexico do in this example. So always make sure you meet the visa requirements for those countries based on your home passport, because you don't show them your green card for the most part. You use your green card to re-enter the United States. The next major issue that arises when you try to re-enter the United States is admissibility. You might be deemed inadmissible, and this typically happens if you've been convicted of a crime. And I've seen people who were convicted of a crime 15 years ago. Since then, they've renewed their green card without issue. And then they leave the US, and when they come back, the customs officer says, hey, you committed this crime, you're inadmissible, which literally means we are not going to admit you to the United States as a permanent resident. Best case scenario in that situation, you'll receive a notice to appear in immigration court, which will begin deportation proceedings. You might be eligible for all sorts of defenses. I represented a guy once who was convicted of robbery in New Jersey, and he wasn't actually inadmissible. The customs officer made a mistake, so we were able to easily defend his deportation and get the removal proceedings terminated. That was a lucky outcome. That doesn't usually happen, but you might have other defenses available to you. So if you've ever been convicted of a crime and it's been a while since you've left the United States, or you're planning on leaving the US after a final conviction for that crime, you need to speak with an immigration lawyer who can do a little bit of legal research to make sure that crime doesn't make you inadmissible to the United States. An interesting side note is that oftentimes the way to fix or cure these inadmissibility issues is to stay in the US, wait 5 years since you've finished the penalty for the crime, like probation. You would have to wait until probation is done and served, calculate 5 years after that, apply for US citizenship, and once you become a US citizen, then you can leave the US without facing inadmissibility if you return to the US. So you might actually be able to apply for citizenship, but not re-enter as a permanent resident because of inadmissibility. The final comment I want to make is that sometimes there are travel restrictions. During the COVID pandemic, some permanent residents left the US and were unable to come back for a very long period of time. And they faced abandonment issues, and it was a really stressful situation for anyone who was in that position. The general rule for abandonment is what your intent is, what your mental state is. If you're physically prohibited from coming back because the airline has no flights and because it's all a state of emergency, and you can show that you tried and you intended to come back, you intended to maintain a permanent residence in the US, then it doesn't actually matter how long you physically spent outside of the United States. It's all about intent. Even if you spent 3 years out of the US, as long as you can show you tried to come back within a few months of leaving, that's generally enough to maintain your permanent resident status. Alright guys, so that brings us to the end of this video. Just one caveat. I can only advise about immigration law in the United States. If you want to travel to another country, I'm not legally allowed to give you advice about the visa requirements or passport requirements of those countries. I can only discuss US immigration law with you. But if you do have an immigration law question in the US and you want to consult with me, please feel free to schedule a consultation directly through my website. You could also call or text us and we'll get the ball rolling and schedule something for you. I represent people all over the United States, so don't be afraid to call. If you're new to my channel, please be sure to like and subscribe. I make a new video on an immigration topic every week, and I'll see you guys next week.